his life. Article 9 recognizes the right to liberty and the security of a person and prohibits arbitrary arrests and detention. Article 14 of the ICCPR provides, and I quote, that in determination of any criminal charge against him, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. The subsets of this right in paragraph 3 of Article 14 include the right, and I quote again, to be tried in his presence and to defend himself in person or through legal assistance of his own choosing, to be informed, if he does not have legal assistance, of this right, and to have legal assistance assigned to him in any case where the interests of justice so require. In order to make these salutary principles a living reality, where a national of one country is being tried in another country, adherence in letter and spirit to the Vienna Convention becomes a vital step. Mr. President and esteemed members of the Court, I say with all the emphasis at my command, the graver the charge is, the greater the need for punctilious adherence to the Convention. Although the Vienna Convention predates the ICCPR, international law and its jurisprudence, especially in the dimensions of human rights, have evolved with time, and the interpretation of the Vienna Convention and the implication of the rights guarantees must be informed by current standards of conduct expected from sovereign states. The Vienna Convention embodies a vital code of conduct that would give life and meaning to the right to fair trial to a national of one state arrested in another state. The content of Article 36 of Vienna Convention in the present times must be informed by international jurisprudence, which includes the salubrious principles recognized by ICCPR. As held by this court in Avena, and I quote, violations of the rights of the individual under Article 36 may entail a violation of the rights of the sending state, and that violations of the rights of the latter may entail the violation of the rights of an individual, end of quote. Where the rights of an individual are violated, consequences must follow. The Vienna Convention recognizes the right of a state to seek redress on behalf of its national in this court, where the rights of its national and concomitantly its own rights under the Vienna Convention are violated by another state. The facts set out in our application, alluded to by me briefly, establish egregious violation of the Vienna Convention. The events that have transpired since March 2016 establish the farcical nature of the trial and leave no manner of doubt that in the present case the violation of consular access in the Vienna Convention has been destroyed, and this has destroyed any credibility and sanctity that the verdict of the military court in Pakistan may have in international law. India invites the attention of this court to Pakistan's conduct that violates the Vienna Convention, and I shall focus on one or two issues. In its letter of 21st March, Pakistan responded to the request for consular access stating, and I quote, the case for consular access to the Indian national shall be considered in the light of Indian side's response to Pakistan's request for assistance in the investigation of early dispensation of justice. End of quote. This is completely an untenable position. I submit, Mr. President and esteemed members of the court, this is completely untenable position. And it's a clear violation of the Vienna Convention. Article 36 confers the right upon individual and upon the state. Firstly, the right of an individual to consular access cannot be made hostage to demands for assistance in investigation and the response of the state whose national is being deprived consular access. Secondly, the Vienna Convention doesn't countenance any such exceptions. Thirdly, I repeat, the more serious the charge, the greater the need for procedural safeguards to ensure that the accused gets a fair trial. In the circumstances of this case, where the accused has been, by March 2017, for a year in military custody, incommunicado from his family and from his home state, the suggestion that there has been a fair trial without allowing consular access is patently untenable. The trial stands vitiated in international law for egregious violations of the Vienna Convention. The press release of 10th April 2017 announcing the award of death sentence and its confirmation by the Chief of Army Staff stated that Jadhav confessed before a magistrate, and his confession was that he has been asked to coordinate and organize espionage and sabotage activities, etc. In the absence of any information as to the evidence led against him, other than his confession, it can fairly be assumed that the confession played a significant part in his conviction. The confession was extracted when he was in military custody, incommunicado, and continuously denied consular access. The repeated assertion that he was afforded a fair trial when his basic rights under the Vienna Convention were thrown to the winds ring hollow. India seeks the intervention of this court to address the injury caused by the violation of the Vienna Convention. And Mr. President and esteemed members of the court, I respectfully submit the existence of any other remedy, even assuming such remedy does exist in domestic law of Pakistan, does not bar invocation of the jurisdiction of this court. The assertions by Pakistan in its communication of 12th May that there are remedies available to Jadhav have to be viewed in the backdrop of the circumstances of the case. And two of the circumstances are important. At the appellate stage, Pakistan steadfastly refuses to allow consular access. Not that access at this stage would cure the fatal defect in the process that led to his conviction. It only shows that the illegality arising out of violation of the Vienna Convention continues unabated. The information in public domain suggests that the appeal will be heard by a tribunal presided over by a two-star general. The death sentence stands confirmed by the Chief of Army Staff, a four-star general. It strains credulity to believe that the Court of Appeal will have the degree of impartiality and independence and decide the matter uninfluenced by these events. The appeal will be heard when Jadhav continues to be incommunicado and deprived of consular access. The military spokesman candidly, in his press briefing, admitted that he did not see any chance of the verdict being overturned. From the information in public domain, Jadhav would not have access to legal representation of his choice. It was reported, and it has not been denied, that the Lahore High Court Bar Association has threatened to cancel membership against any lawyer pursuing appeal of Jadhav against his conviction. Thus, Jadhav has neither consular access nor prospects of finding proper legal representation, even at this stage. In any event, Mr. President and esteemed members of this court, I respectfully submit that no legal remedy that will redress the injury caused by the violation of the Vienna Convention. Spokespersons of Pakistan have already clarified their stance that the consular access under the convention would not be allowed, which comments are consistent with Pakistan's communications to India. Pakistan continues to make allegations suggesting that Jadhav was a commander in the Indian Navy and an Indian spy. India refutes these allegations as being baseless and being part of a propaganda war relentlessly waged by Pakistan. India asserts that Jadhav retired from the Indian Navy and has been pursuing business in Iran from where he was kidnapped. But, Mr. President and esteemed members of the court, the merits of these allegations and counter-allegations between the two countries are irrelevant for the case which you are going to decide. The seriousness of the allegations only underscores the need for strict adherence to the procedural rights and safeguards to an accused, not merely under domestic law, but in the case of Jadhav, also under the Vienna Convention. India submits, therefore, Mr. President and esteemed members of the court, India submits that it has a strong prima facie case as to the jurisdiction of the court and on merits sufficient to justify seeking of provisional measures. India, in its relief, seeks restitutio in integrum, which would, in the least, finally require annulment of the verdict. In the circumstances, I submit that India has a strong case for provisional measures as an indication that the death sentence be not executed until such time as the court has adjudicated India's applications. And therefore, sir, on behalf of the Republic of India, Mr. President and esteemed members of the court, I beseech you that please put in place, please indicate provisional measures that A, the government of Islamic Republic of Pakistan take all measures necessary to ensure that Kulbhushan Sudhir Jadhav is not executed. B, that the government of the Islamic Republic of Pakistan report to this court the action it has taken in pursuance of the indication. And C, that the government of the Islamic Republic of Pakistan ensure that no action is taken that might prejudice the rights of the Republic of India or of Kulbhushan Sudhir Jadhav with respect to any decision this court may render on the merits of India's application. Thank you, Mr. President and esteemed members of the court.
Thank you. I now give the floor to Dr. Deepak Mittal, the agent of the Republic of India.
Thank you, Mr. President and esteemed members of the court. I thank the court for the patient hearing. As the Counsel for the Republic of India has already read out, I formally once again
हम आपको अभी लिए चल रहे हैं एक बार फिर मध्य प्रदेश की ओर अमरकंटक में, जहां पर प्रधानमंत्री मोदी मौजूद हैं नए मिशन की शुरुआत करने के लिए।
जी आज नर्मदा सेवा यात्रा के पूर्णता पड़ाव पर अब मानवता की पोषक भारत की सभी मातृ रूपा नदियों के संदर्भ में विश्व के समक्ष